Okay, I think we are expecting a few more people, but we've got a lot to get through, so I think we should make a start. So welcome everyone. Thank you for joining us. This is our latest series of MiCA webinars. So I'll start off with a few housekeeping matters. The main presentation will run for approximately 40 minutes, and we will have a 5-minute introduction, and then we'll leave around 10 to 15 minutes at the end for a Q&A session. If you have any questions, please post them in the Q&A button and not in the chat button. We will be using the Q&A for questions, and then the chat, you can chat amongst yourselves or ask directly with us, with any one of the panelists. We will also be keeping the call open for a post-webinar networking session to answer any outstanding questions, so feel free to stay a bit longer if you want. So here's our agenda for today. I'll be giving you a little bit of an introduction to Xrig and the presenters. There'll be a bit of a background and overview of MiCA, the objectives of MiCA. We'll be talking about the timeline for the adoption of the legislation, a little bit about what's in and out of scope of MiCA, what are the key requirements for the different types of entities that are caught within MiCA. We'll be talking about who are the different regulators within the EU. Then we'll be given a little bit of an overview of the application timeline for stable coins and crypto asset service providers, a timeline for implementation of the legislation. Finally, we'll be talking about what's coming next in level 2 measures, and we'll have the Q&A session after that. I'll start off with a short introduction of the Xrig group and the speakers. So Xrig, who are we? We're a boutique public policy and regulatory affairs consultancy specializing in crypto assets. We're now a 27-strong and growing team of mostly former regulators and policymakers, all with practical experience in the development of regulatory compliance strategies. Our clients include private crypto companies, governments, regulators, and public bodies. We provide policy and strategic advice to the public and private sectors globally. We carry out jurisdictional reviews and gap analysis for crypto asset businesses to help them understand and meet regulatory obligations and what might be the best jurisdiction for them. We help governments and other national authorities in the design, development, and implementation of legal and regulatory regimes. And we also offer training and education on crypto assets generally and DLT, helping teams upskill and build the necessary capacity to regulate and supervise this sector. So I am Ernest. I am one of the founding partners at Xrig and the legal and regulatory policy lead, and your moderator for today. And helping you to explain MiCA to you today are David, who's a consultant leading on a variety of client engagements, including licensing and registration applications, product and service mapping exercises, jurisdictional analysis, and AML independent audits. And David is also a key member of the MiCA team at Xrig. And we've got Lloyd, who's Xrig EU policy lead. He focuses on public policy affairs and assists clients with navigating the complexities and opportunities around MiCA and all applicable legislation. So, by way of background, the first draft of MiCA, as a lot of you would probably know, was issued back in, published rather, back in September 2020. And back then we delivered a series of webinars, and today marks the start of our next series of MiCA webinars. Back then we issued a MiCA explainer, which we have recently updated. We issued it last week. So if you haven't received a copy and would like one, please send us your details in the chat or via the contact email address, which you will see at the end of the slides. So what is MiCA? In short, it is the piece of EU legislation, very comprehensive, regulating crypto asset issuers and intermediaries such as exchanges and custodians. Many are saying that MiCA is a model to follow, especially in the current climate. It will no doubt have a significant impact on the crypto industry, and not only impact EU-based entities, whether they are currently registered or not, or licensed, but also other global firms who are looking to set up in the EU or service EU customers. MiCA has evolved a lot over the last few years, and it is still subject to some further changes before it's finally adopted. It is very close to the end of the legislative making progress in the EU, and it is soon to become applicable EU legislation. So why is this relevant? So MiCA, unlike directives, is an EU regulation which has direct application, meaning that it would apply directly across EU member states and European Economic Area jurisdictions without the need for much, if any, national implementation. It aims to achieve as much uniformity as possible across the EU, but there are still some nuances, some practical aspects of it that may not be applied in the same way by national competent authorities. There are still some areas that require further clarification to avoid different interpretations across EU member states. However, in principle, MiCA purports to ensure that the authorization, supervision, and enforcement of these entities is done to the same rules and standards across the EU by national competent authorities. Importantly, there are two European supervisory authorities, the European Banking Authority and the European Securities and Markets Authority, which will play a key part in MiCA. They will need to supervise some entities that exceed specific thresholds in conjunction with other national competent authorities. Also, it is key to note that MiCA is just one piece of the puzzle. There are level 2 measures, guidelines, and other measures that will also apply. But first, it's important to understand MiCA. There are also other measures that are part of the digital finance package, such as the Digital Operational Resilience Act, which will apply to crypto asset service providers. In addition to that, there's other existing EU legislation that will be applicable to a CASP, regardless of MiCA. So, for example, the Anti-Money Laundering Directive, which currently applies to crypto asset service providers that may be providing services across the EU. Finally, but very importantly, one should keep in mind the current fragmented legislative and regulatory crypto asset frameworks across the EU, most of which have some kind of AML regime, but others have a broader regime which may be closer to MiCA, but not quite equivalent. So EU member states will need to transition to MiCA. And what will this mean to them? It will be different according to the member states, the type of regime that they currently have in place. Some national competent authorities may have a dedicated crypto asset team, others don't. So this will mean that it will be a steep learning curve for a lot of them and a period of adaptation. And with that, I will now hand over to David, who will take you through the MiCA objectives. Thank you.
Thanks, Ernest. So as already mentioned, MiCA is the EU's soon-to-be adopted markets and crypto assets regulation. In short, it sets out the rules for crypto assets and related activities across the Union. It is an attempt to harmonize at EU level the fragmented regimes already applied across the 27 countries that make up the European Union and the 3 other countries in the European Economic Area. It'll look to ensure the proper functioning of crypto asset markets, the protection of holders of crypto assets and clients of crypto asset service providers. It'll also look to ensure market integrity and financial stability, and it aims to allow for a large cross-border market to develop in Europe around crypto assets. For this webinar, if you're a provider of crypto asset services, for example, an exchange, you're going to want to look out for whether your services are captured within the scope of MiCA and what your obligations will be under this regulation. Likewise, if you're an issuer of stablecoins or other crypto assets, look out for what is in the scope of MiCA and what's left out, who will be regulating you, as well as what's likely to come as part of the level 2 legislation, i.e. the development and guidelines and the development of guidelines and technical standards. So this timeline shows the steps taken in the process to adopt MiCA into law. This all began in September 2020 when the European Commission proposed this regulation. And as you can see, it's been through the normal EU legislative process of refinement over the last 2 years. In October last year, an agreement was achieved on the draft report of MiCA between the governments of the member states and the EU Parliament. But let's look to the right-hand side of this timeline, showing where we're at now. So it's important to note that practical changes are happening all of the time. Last week, since we published our explainer, and most people were pretty confident of the timelines, things have changed. And as seems to be all too common with MiCA, it's very possible that we could see even further, see changes even further. But here's where we currently stand. So an agreement has been reached on the text in one language, And now MiCA is in the process of being translated into all of the EU's other official languages, which is no small feat given that each language version of this will be authoritative. The MiCA text will then go back to Parliament for a vote. It was announced recently that this vote would be pushed back to April, following issues in translating such a lengthy document into so many languages. This in turn will push the publication of MiCA in the official journal of the EU back to Q2 of this year. 20 days after this publication, MiCA becomes law. I'll pass over to Lloyd now to talk a bit about the scope of MiCA, what's in and what's out. You're on mute, Lloyd.
Sorry about that. Thanks very much, David. Let me pick up on a theme that David's mentioned, and so has Ernest, in terms of harmonization and what we mean by harmonization. So that's achieving high common standards in the crypto asset space, a kind of uniform leveling up across the EU in exactly the terms that David mentioned. So proper consumer protection measures for holders of crypto assets and clients of crypto asset service providers, also in terms of market integrity and financial stability, and also to scale up activity, crypto asset activity across the EU. And so with all that in mind, you'd expect MiCA to be pretty comprehensive, and it is. It's very comprehensive. It sets out to be comprehensive, to cover all these different areas. So maybe let's just launch into the 5 major areas that MiCA regulates or addresses. So the first bullet point there would be the issuance and offer of stable coins, so electronic money tokens, EMTs, or asset reference tokens, ARTs. And maybe let's just pause there a second so we're all on the same page as to what we mean by stable coins and AMTs, ARTs and EMTs. So EMTs would be a token that is stabilized or purports to be stabilized by reference to an official currency, a fiat currency, just one. That's an EMT. And an ART, that type of stable coin, is a token, ART is a token that is stabilized by reference to a combination of assets. It could be fiat currencies, it could be crypto assets, it could be a combination of fiat currencies and crypto assets, just to have those definitions in mind. That was the first one. The second one is the issuance and offer of crypto assets other than ARTs and EMTs. So this is kind of a catch-all category, and probably most utility tokens, for example, would fit in this particular category. Okay, so that was the second point. The third one is services provided by crypto asset service providers. So if you're in that area, or you think you are, maybe have a listen to this partial list of services which I've set down and maybe of interest to you. So what does it cover? Well, things like the custody and administration of crypto assets for third parties, the operation of a trading platform, the exchange of crypto assets for funds, the exchange of crypto assets for other crypto assets, providing advice on crypto assets, or providing portfolio management on crypto assets. Yeah, so all those count as services, and if you're in those areas, and there are more, by the way, that's going to be important for you to pay attention and see whether you're captured by MiCA. So the fourth area addressed by MiCA are mechanisms that prevent market abuse, and there's a particular emphasis in MiCA on market manipulation and insider trading. And finally, the fifth area is the supervisory, or supervisory, if you prefer, architecture of the EU's crypto asset framework. And what I mean by that is the kind of allocation of obligations on the part of national competent authorities, the NCAs that Ernest mentioned, and the kind of European level. So if you're listening from, I don't know, the States, then sort of federal level regulators, and that includes the European supervisory authorities like the European Banking Authority and the European Securities and Markets Authority, and also separately the European Central Bank. Okay, so they also have a role to play, and MiCA sets out what role they have to play. Okay, so that's what's in. What about what's out? That's the next slide. So again, this is kind of a sampling of what's out. Some things are explicit in MiCA, other things you sort of have to figure out. So this doesn't pretend to be comprehensive. But one important area that's left out is decentralized finance. Yeah, but an important qualifier here, decentralized finance, the service is provided in a fully decentralized manner. So if it's even partly centralized, then it may not be out, and it may be captured, in fact, by other EU financial services legislation. So one to watch out for there. Second one, non-fungible tokens, NFTs. So again, they're out, but there's a qualifier you need to be aware of. If there's an aspect of the token that's fungible in any way, or not unique, then you could be in scope or indeed captured by other EU financial services legislation. So you need to be careful of that. And certainly just labeling something an NFT wouldn't be enough. Yeah, it's a substance over form approach that the EU takes and that MiCA takes in terms of NFTs. So it's got to be a real NFT, to put it that way. A third area, lending and borrowing of crypto assets, that's completely out of scope, and it may well be addressed in the future in some kind of MiCA 2, but for now it's not there. Crypto assets under existing EU financial services legislation. So quite specifically, if a crypto asset meets the definition of a financial instrument as defined in what's known as the Markets in Financial Instruments Directive, which is another piece of EU law, then it's out. Also utility tokens representing an existing good or service, and then a series of other tokens, for example, tokens linked to blockchain loyalty programs. Okay, so that's all out, but there's other stuff that's out as well. This is just to give you an idea of some of the important items. Okay, so maybe we could move on now to the key obligations in relation to issuers of stable coins. So let's begin with ARTs. There is, as you'd expect, an authorization process for ARTs. So that comprises essentially a white paper full of formal and substantive information, and that has to be accompanied by a legal opinion attesting to what kind of ART it is, and indeed whether it is an ART. So that needs to accompany the white paper. Uniquely to ARTs, there are also reporting obligations. So for example, if the issued value is over 100 million euros, then there will be quarterly reporting to the national regulator. So that's ARTs and their authorization process. I should maybe emphasize as well, actually, in terms of the authorization process, that the white paper has to be approved, yeah? It has to be approved by the national regulator. I'll contrast that now to EMTs and their authorization process. And the contrast consists of this. If you are an issuer of e-money tokens, then you have to be or become a credit institution, a bank, effectively. You need to get a banking license, or you need to be an e-money institution. There is a white paper requirement, but it's just a notification requirement. So you notify the white paper to the national regulator. And that leads me, again, some of the cross-cutting issues, and you'll see that under the bullet point both. So the white paper, again, the substance of the white paper, and this cuts across ARTs and EMTs. So information about the issuer itself, or the offer, so the legal name, the structure, that kind of thing. Information about the nature of the token, the business project itself, that needs to be covered in the white paper. Also an explanation of the rights and obligations attached to the token itself. Crucially, information about the underlying technology being used. And also any adverse environmental impacts in relation to the issuance of the crypto asset. Okay, in terms of the reserve of assets, that's the second bullet point down under the third heading on your screen. So there needs to be a reserve of assets. Again, not least because AMTs and ERTs, but in particular AMTs, have the potential to be very destabilizing. And in terms of consumer protection also, there is this requirement that they have a reserve of assets. And crucially, those assets need to be segregated from the issuer's own assets, which is what you'd expect. And that's to protect them also from creditor claims in case of an insolvency. That reserve of assets needs to be sufficiently liquid to preserve the permanent redemption rights of token holders. So token holders have permanent redemption rights. And another aspect of the reserve of assets is that the custody of those reserve of assets has to be entrusted to credit institutions, again, banks or investment firms. Quick word on redemption. So I've already mentioned that stablecoin holders have the right to redeem their tokens, and that can be at any time, directly or against the reserve of assets if the issuer cannot meet its redemption obligations to the holder. And finally, another point there to bear in mind is that the redemption cannot be subject to any fee. Okay, minimum capital requirements. A quick word on that. For ARTs, issuers will be required to maintain capital that is the higher of 350,000 euros, a quarter of fixed overheads, or 2% of the average amount of reserve assets. And EMTs are subject to a 2% requirement by reference to the amount of issued e-money. It goes up to 3% if they're a significant EMT, and we'll discuss that a little bit more in a couple of moments. Prohibition of interest. There is an absolute prohibition of interest. You cannot pay interest to a holder of a stable coin. And the reason seems to be that the EU wants to discourage stable coins from becoming a store of value. Okay. In terms of recovery and redemption planning, the key there is to have a plan. You must have a plan setting out how you as an issuer of a stable coin will meet your obligations in case of potential market disruption, which could reverberate on you as a business and which would prevent you from meeting your obligations toward token holders. Okay, and a final word, the last bullet point there on significant stable coins. So significance is determined by a set of 3 criteria, and I'll mention 3 of a whole list of criteria that MiCA lists. So this could, this includes the number of holders, market cap, that kind of thing. And if they're significant, then you as an issuer are subject to higher supervisory obligations, for example, liquidity stress testing. Okay, maybe we can move on then to the next slide, which is key obligations for other crypto assets. I've already mentioned this is kind of a catch-all category. So you're not an EMT or an ART, you would likely fall under here. So a very light regulatory regime. You don't need to be authorized by the national competent authority, by the national regulator. You do, however, have to publish a crypto asset white paper and notify the national competent authority before offering the token or admitting it to a trading platform. And that means once you've done that, you can offer it across the EU under what's known as passporting rights. Okay, so on the next slide, we'll discuss obligations of crypto asset service providers. So a fairly heavy set of obligations if you're a service provider. You must be authorized in an EU member state to carry out the crypto asset service. To be authorized, you have to have a registered office in the EU. So that's, again, a really important one to bear in mind if you're thinking of doing business in the EU. And also, effective management of the service provider has to take place within the EU. Also, again, very important from the point of view of business practicalities, at least one director has to be resident in the EU. On governance, just moving down, this is the 3rd bullet point on your slides. So members of a CASP management body are required to have a sufficiently good reputation and possess knowledge and skills to perform their duties, which is what you might expect. And also you have to have a plan in place as a CASP to ensure that compliance with those management body requirements is met. Capital requirements, so you need to maintain as a CASP a minimum capital that is the higher of 50,000, 125,000, or 150,000 euros, depending on the service that you're providing or services that you're providing, or 1/4 of the fixed overheads of the preceding year. Safeguarding measures, just to give you an example of what that could entail, that would be things like putting your client money, and this is an actual requirement, I'm not making that up, I'm just giving it to you as an example. So all money received from clients other than EMT clients have to be placed with a term of art for the EU, a credit institution. It means a bank, a licensed bank, or a central or national bank in the relevant EU country where the CASP is itself established. Just like there are significant EMTs and significant ARTs, there are significant CASPs. And so what defines a significant CASP? Well, at least 15 million active users within the EU. And CASPs, again, are subject to increased oversight and supervision by national competent authorities. Okay, so maybe a quick word on this wider EU ecosystem, which Ernest has already mentioned. So you need to think of MiCA in some ways as a standalone law, but it also fits into a wider cluster of EU laws. And in particular, we need to keep in mind the digital finance strategy of the EU, which is a cluster of about 7 measures. And in respect of CASPs, I guess 2 maybe are particularly worth pointing out. And again, Ernest has mentioned one of them already. So that's the Digital Operational Resilience Act, which has to do with ICT and cybersecurity. And that shouldn't surprise us that CASPs are going to be subject to this, even though it's outside MiCA. ICT being super important. If anything happens, if it's jeopardized or compromised in some way, that could affect the whole financial system. So that's why it's there, and that's why it's CASPs are made subject to it. And the EU regulation on transfer of funds. That's the second law, effectively, of the EU. Again, part of this wider cluster you need to keep in mind. And that has to do with information sharing duties applicable to wire transfers. So remitter and beneficiary details, you may know that as the travel rule. It's widely known as that. And as you'd expect, that's to counter money laundering and to counter the financing of terrorism. So, okay, again, just to keep in mind this wider context within which MiCA exists. And over to you, David.
Thanks, Lloyd. So individual member states of the EU will be responsible for implementing the requirements set out in MiCA, including the authorization and the supervision of crypto asset service providers and issuers. It'll be up to each member state to determine which national regulatory authority will be responsible for implementing these requirements. Some member states have a single regulator responsible for all aspects of regulation of entities, while other member states have separate regulators responsible for specific sectors or aspects of regulation. Some jurisdictions have communicated their plans on this, while others are yet to do so. These national competent authorities will have all the usual regulatory powers, such as requiring information, suspending or prohibiting activities or offers, and carrying out on-site inspections or investigations. Once a CASP or an issuer is authorized by a national competent authority of a member state, passporting provisions will apply in the remaining member states. So this means that the CASP or the issuer will be able to provide services to clients in other member states without the need for separate authorizations or licenses in each state. This will open up services across Europe and allow new entrants to scale. Although it's important to note that firms will still need to register in each country separately under anti-money laundering regulations, even if only one authorization under MiCA is required. If crypto asset service providers or issuers of stablecoins are classified as significant under the criteria set out in MiCA, this is where things get a little more complex. When a CASP has at least 15 million active users in the EU, then that firm will be considered significant. Active is the key word here. It is calculated as the average daily number of active users in one calendar year. The crypto asset service provider must then notify its national competent authority within 2 months of meeting this threshold. So if you're a large exchange and you have more than 15 million active users, you will be treated as significant under MiCA. In this case, although the national competent authority will remain responsible for supervision, it'll have to update the ESMA Board of Supervisors, that's the European Securities and Markets Authority Board of Supervisors, annually on any key supervisory developments. Article 39 of MiCA provides a criteria for the classification of ARTs and EMTs is significant. So asset reference tokens and e-money tokens, which meet at least 3 of the criteria, which is quite lengthy, set out under this article, will be classified as significant, upon which the supervisory responsibilities will then be transferred to the European Banking Authority. If a stablecoin is classified as significant, it'll be reassessed by regulators on at least a biannual basis. So nothing will be set in stone here. Article 40 of MiCA allows issuer of stablecoins to voluntarily ask to be classified as significant during the authorization process. But ultimately, a decision on this will be made by the European Banking Authority. For significant asset reference tokens and significant e-money tokens, the EBA will have the power to request information related to the issuance, as well as investigative powers and on-site inspections. It may choose to delegate some of these supervisory tasks to the relevant national regulatory authority. So 20 days after MiCA is published in the EU official journal, the transitional period will then begin. This will be the time that each member state has to make all necessary arrangements to implement the framework. This will include designating a national competent authority that will be responsible for MiCA, as well as setting up internal processes and training staff. During this period, firms captured by MiCA and looking to apply for authorization will also have to prepare for the impending requirements. There are 2 transitional periods depending on the type of entity. The first, for crypto asset service providers, is 18 months from the date the text is published in the EU official journal. And for issuers of asset reference tokens and e-money tokens, the transitional period is 12 months. After this transitional period, there's a period in which firms already operating in EU member states will be able to continue offering services known as a grandfathering period. Crypto asset service providers already providing services in accordance with applicable national law will benefit from an additional 18 months to provide those services. It's important to note, however, that member states can decide not to apply this grandfathering period for crypto asset service providers, or they can reduce its duration if they believe MiCA will result in stricter requirements than those set out in their existing national frameworks. Issuers of stablecoins, so asset reference tokens and e-money tokens, which have already issued these and may continue to do so up to 1 month after the 12 months transitional period. For credit institutions, this simply requires that they notify the national competent authority and comply with applicable requirements under MiCA. Issuers that are not credit institutions have this 1 month following the transitional period to apply for authorization under MiCA. New applications for authorization under MiCA will need to be submitted once the member state has its regime in place and has indicated that it will start accepting applications. As we saw in the previous slide, member states have up to 18 months to implement a framework for the regulation of MiCA. It is likely, therefore, that the member states will be ready to start accepting applications at different times within that 18-month period. What may be very advantageous to crypto asset service providers considering applying under the MiCA regime is to set up in the European Union now in order to benefit from that additional 18-month grandfathering period that was mentioned earlier. This will mean that different requirements depending on the jurisdiction, but in some cases may only require registration under the relevant AML law, which would be far less onerous than applying under a full regime. What is clear, however, is that the application timeline itself, national competent authorities will have a total of 70 working days to process an application. The speed of this, of course, will depend on whether the application provided to them is complete. They'll acknowledge receipt of the application within 5 working days. There'll be another 20 working days for the national competent authority to decide if the application is complete or whether they require further information from the applicant. And if it is deemed complete, the NCA will have 40 days to make a decision on whether to grant or refuse authorization, and a further 5 working days to inform the applicant. So in short, if your application is complete, this is going to take at least 3.5 months. The stablecoins, the timeline is slightly longer and a little more complex. So the NCA has 25 days to communicate if the application is complete, another 60 days to communicate a draft decision on the application to the various EU institutions, so the EBA, ESMA, and the ECB. These institutions will then have 20 days to issue an opinion on the application, and it'll be up to the NCA to decide to make a decision another 30 days later. So this application will take at least 7 months, and this is because the NCA will need to coordinate with the various EU institutions on this. So what's next? Well, Q2 this year, as already mentioned, is now the expected date of adoption for MiCA. Following the publication of MiCA, the process to start drafting the technical standards will also begin. We expect the national competent authorities, ESMA, the ECB, and the EBA to start drafting these in the coming months. 12 months after MiCA's entry into force, and every year after that, ESMA will be responsible for generating an annual report on market developments. So this will include an update on areas such as the number of issuances of crypto assets or stablecoins in the EU, the number of crypto asset service providers, and some more interesting figures such as the number of complaints received by crypto asset service providers. In terms of the future focus for MiCA, within 18 months, the European Commission will produce a report to assess the necessity and feasibility of regulating DeFi systems, the lending and borrowing of crypto assets, and offers of NFTs. While these concepts are currently out of scope of MiCA, this gives us a clue as to what may be included in the second iteration of the regulation. Within 48 months from the date of MiCA coming into force, the Commission will present a report to Parliament and the Council on the application of MiCA, and this will look at the state of the crypto asset market in the EU and whether any of the scope, definitions, and exemptions under MiCA will require amending. And all this means that it will be very important to maintain engagement with these European institutions. This is not a one-time engagement with the crypto industry. This regulation will continue to evolve. And like I said, staying engaged with these policy and legislative institutions will be key. I'll hand back to Lloyd, who's going to talk a bit about the level 2 legislation.
Thanks very much, David. And as David's already suggested, there's a lot more to come, as if 400 pages of MiCA isn't enough, and that's including 6 annexes. There's a lot of detail yet to be worked out. So let me begin by talking about delegated acts and regulatory and implementing standards. I guess the important point for you to be aware of is that these particular measures bite, so they're binding, they have the force of law. And there's a lot of them that is, again, David has mentioned, will be coming out in the next 18 months. One key one is definitions within MiCA itself. So even the definition of a crypto asset or an EMT or an ART, those can be changed by the Commission. And that's pretty important because that'll reverberate across the rest of the text and, interpreting that text. So that's one to look out for. And by the way, they can do that at any time. So that isn't just something that they will do within the next 18 months and then forget. That's an ongoing power that they would have in the future. So you need to be very alive and attentive to that. A second one, again, bearing in mind this is just a sampling of what's coming next in level 2, the criteria for significant stable coins. So we have them now, but they could be fine-tuned or otherwise changed. So something also to look out for in terms of what's coming. Obligations for crypto asset service providers to ensure liquidity of ARTs, of the issuers. So if you're in that area, if you're an issuer, that's going to be important to you to understand. And the last one there, the fourth bullet point, is more of an administrative one, but no less important in terms of practicality. So standard forms for reporting to the national regulator or the European supervisory authorities when needed, for example, when you're a significant issuer or CASP. So a practical one, but important. And if we move to the next slide, these are guidelines, so they don't have the force of law or won't have the force of law, but they're very important. The first one I mentioned there, criteria and conditions for qualification of crypto assets as financial instruments. I mean, that's going to be key because, as we've already mentioned, you a crypto asset could come under MiCA, and many of them will, maybe most of them will. But you could come under MiFID, the Markets in Financial Instruments Directive, under Article 4 there, which defines financial instruments. So there's going to be a kind of a gray zone between those two, and it'll be really important to look out for what guidance is issued by the European supervisory authorities to try and help people in this space to understand where one will fall as opposed to another in another piece of legislation. Okay, services of transfers for e-money tokens, just another guideline that's going to be coming out there that could be of interest if you're issuing e-money tokens. The minimum content of governance arrangements for ART issuers, and we've already mentioned the fit and proper test for management bodies, etc. So more will be coming in terms of refining those details. And last but not least, again, bearing in mind this is just a sample of what's coming. There's a lot of guidelines coming, a lot of other measures. Portfolio management of crypto assets by crypto asset service providers. And that's it from me for now.
Thank you, Lloyd. Thank you, David. Thanks, everyone. We've got a few questions in the Q&A section. We also have a few questions in the chat, but I think they are mostly around the presentation. We've had questions of whether we'll be sharing the presentation after the webinar. I know Ali has confirmed that we will be sharing it, and we can share it as a PDF. We will also be sharing the recording. We will be providing a link to that, so you'll all be able to have access and share it among your colleagues and others. We also have a few questions on the Q&A section. And I would encourage you to raise your hands if you have any other questions, and we can open the floor and let you ask the questions as well. So one question from an anonymous attendee. So labeling something as decentralized won't be sufficient to be out of scope, right? David, do you want to take that one?
Yeah, so you can't just label something as decentralized to ensure it's out of scope. This will only apply to true decentralized services. So the regulation will apply. Sorry, the regulation won't apply if services are provided in a fully decentralized manner without any intermediaries. So that's going to fall out of scope. But that's the key. So you're providing services without any intermediaries. It's quite clear on that.
And hopefully something that will clarify that is the report that will be prepared over the next 18 months in relation to decentralized finance, and we'll need to wait and see whether or not there are other changes that will be made to MiCA as a result of that. We have another question around significant issuers. I assume we're talking about significant issuers of EMTs or ARTs. So what are the criteria to be considered a significant issuer? David?
So a significant issuer of asset reference tokens and e-money tokens. This is Article 39 of MiCA. And you need the criteria has to be at least 3 of the following. So it's the number of holders of the asset reference. If the number of holders of the asset reference tokens is larger than 10 million, the value of the asset reference tokens issued, their market capitalization or the size of the reserve assets is higher than 5 billion euros. The number and value of transactions in those asset reference tokens is higher than 2.5 million transactions and 500 million euros respectively per day. And the issuer of the asset reference tokens is a provider of core platform services designated as a gatekeeper. It's quite lengthy, but it's Article 39 of MiCA.
Great, thank you, David. We've got Frederick Hannison has raised his hands. Can we let him speak, please?
Hello, can you hear me?
Yes, we can.
Perfect, thank you. I want to follow up on the decentralization question, which was already raised. And I was wondering the following. So decentralization, from my perspective, is a scope, right? So there's no clear line on what is decentralized and what is not decentralized. Maybe you can decide on the one hand where it is definitely decentralized and where it's maybe not definitely centralized. But on the other hand, I was wondering where these where guidance in regards to decentralization is going to be provided and by whom. I couldn't find anything there. Could you maybe provide some clarity there? Thank you.
Yeah. Lloyd, maybe you can speak to that.
Sure, happy to, and thank you, Frederick. Yes, I mean, you're quite right, and like all of these things, it'll be a bit hard to define at any particular moment. It will be the European supervisory authorities who will advise the Commission on where the line ought to be, and I guess really what we're looking for in DeFi, more than that, in terms of the report that David mentioned, is more of a comprehensive look at this area, and that may well come out in a MiCA too, but I don't think we're going to get necessarily a lot in the meantime, and like many of these terms, there's going to be some contention around, you know, the gray area between centralized and decentralized. But in principle, in the way David explained, it's out.
Thank you, Frederick. We've got a few other questions in the Q&A. So another anonymous attendee is asking, will certain regulations, for example, MiFID, supersede MiCA applicability? I'm happy to take this one. So MiCA, as I think we've mentioned, MiFID is a markets in crypto asset, in markets in financial instruments directive. There are a lot of questions around whether or not certain crypto assets fall within the definition of a financial instrument. So MiCA does not purport to supersede MiFID in any way, but there may be some consequential amendments necessary to MiFID once some of these issues are clarified as to its applicability. But the straight answer is that it won't. We've got a question from Julian Gusua. He's asking, would you please explain the differences between CASPs, issuers of EMTs and ARTs, and custodians? Who would like to take this one?
I mean, I can have a stab at it if you like, but basically, Julian, in terms of CASPs, so those are service providers, they're not issuers themselves. That's the key distinction. So they'll deal with a number of issuers, and they may have obligations as a custodian toward those issuers, for example. But I guess the big distinction really is that they are, by definition, service providers, not themselves issuers, and they therefore come under different regulatory obligations.
So they're very different type of entities. We've got those that issue those tokens, which are stable coins, and then CASPs are the intermediaries, which are very similar to other intermediaries in the traditional financial services arena, which provide services, and they could provide services in relation to those type of stable coins, ARTs or EMTs. Okay, we've got quite a few other questions, and I've seen that some questions are coming through the chat as well. Okay, an anonymous attendee is also asking if there is any clarification about whether clients staking assets change their classification from a crypto asset to a security, as may happen under the US Howey test. David, do you want to have a stab at that one?
Sorry, just repeat that one, please, Ernest.
Yeah, so whether there is any clarification about whether any client that are staking assets, does that change the classification from a crypto asset to a security, as may happen under the US Howey test?
I think that's something I'd have to check and get back to you on that one. I haven't seen anything in MiCA, but I can't speak to that one definitively.
Okay, thank you. Another question from an anonymous attendee. What happens if you don't do what you're supposed to do once the law once it becomes law under MiCA. So once the law comes into effect, what happens then?
So I'll have a go at that one if that's all right. But I mean, there's a whole host of things that could happen. You know, you could be asked to suspend issuance, for example, of tokens if you breach something. It really depends on what you breached. So it's possible under you know, by the national regulator will remove your license, suspend your license itself if it's a severe enough infraction or a breach. So there's a whole host of remedies that the regulators will have at a national level and at the supervisory level, at EU level, but it really will depend on exactly what the breach is. They try and be proportionate about these things. So not because you've, you know, committed some kind of minor infringement will you be suspended or will your authorization be taken away. So you'd have to be, in a sense, more specific about the particular breach to get an answer from MiCA.
Great, thank you, Lloyd. Got another question from Danny. Will all EU countries crypto AML registrations grandfather into MiCA, or is it only specific jurisdictions?
So by this one, do you mean if you're operating in an EU country under the AML registrations? I think that's what you mean. So if you are operating under these under this registration of AML, can you grandfather into MiCA? That applies. That would apply across the board. I mean, it's going to depend on the jurisdiction and what regime they have in place. Some countries might have their own specific regime already, such as France. Some countries at the moment only have an AML regime in place. So I guess it's going to depend on the jurisdiction. But if they only have an AML regime in place, you should be able to grandfather into MiCA from there.
Thank you, David. Yes, and Danny has confirmed, yes, David, is already operating in a EU jurisdiction. Yeah. Got another question from Julian Gousseau. I was wondering if NFTs, cryptocurrencies token exclusively underlied by algorithms such as Bitcoins and utility tokens fall into the residual category and hence be subject to MiCA.
I think that's something we'll have to look into a bit more detail on. It can get quite technical when it comes to NFTs.
Yeah, well, NFTs obviously, yeah, NFTs, we said they fall outside, in principle, fall outside of MiCA. Utility tokens, they do fall within that residual category and therefore subject to MiCA. Crypto assets is very broadly defined, so Bitcoin would come within the definition of a crypto asset. Whether or not some algorithmic stablecoins, for example, fall within the definition of an EMT or an ART, it just depends on the characteristics of each. So yeah, there are going to be some that are in and some that are out of scope, depending on the characteristics. I think I've covered most of the questions.
I think there's one there that you haven't covered, which is how is 15 million quantified?
Yes.
If you're an institutional provider whose 10 clients turn service 50 million plus users, are you classified as significant? And the answer to that one is the MiCA doesn't specify right now. It's 15 million active users for the institution. It doesn't specify on anything about if your clients in turn service users. I don't know if you have a different view on that one, Alyssa, Lloyd.
Seems right to me.
Yeah, sounds right to me as well. We also had another one from an anonymous attendee, which goes on to ask, what's an example of a financial instrument? Can something be both a crypto asset under MiCA and a financial instrument under MiFID? No, the answer is it shouldn't. If it's a financial instrument, it's a financial instrument and it would fall under MiFID. and if it's a crypto asset, it would come under MiCA. At the moment, there are different interpretations across the EU, with some regulators considering some crypto assets to be a financial instruments and others not. So this is where I think some of the guidelines that will be developed that were mentioned by Lloyd earlier on will come in to provide hopefully a lot more clarity, much needed clarity to ensure that harmonization that MiCA aims to achieve, and obviously it's so that it doesn't conflict with other pieces of legislation such as MiFID. Okay, I think we've covered most questions, and we're running out of time. So we said that we'll obviously be happy to keep the call open. So if anyone wants to hang on for a bit longer, we'd be very happy to do that. Open the floor to any further questions or any discussion. Let me take this opportunity to give thanks to David and Lloyd for today. And I also want to thank Alexandra, our head of marketing, without whom we wouldn't be here today. She has made sure that everything runs smoothly for us. And obviously, thanks to all the other team members that have helped us put all of this together. Most importantly, I'd like to give my thanks to all of you for attending today, taking the time, some of short notice. I hope you found it useful, and we appreciate you taking the time to be here today. And as I mentioned before, if you'd like to get a copy of our explainer or any future publications or invites to future webinars, we'll be having another webinar in a couple of weeks' time, where we'll be talking a little bit more about the level 2 measures and what we can expect in those. Please feel free to subscribe via the URL. We have it on our slide there. If not, it will be on our website. Or send us a message in the chat or via email. You can see our contact email address there, and we'd make sure that you're on the list. As I said before, we're going to be closing the webinar now, but feel free to stay on for a bit longer, and we'd be happy to discuss anything further. Thank you, everyone.
And I think Julian just put a question in there, Ernest, to say, please explain more about the XReg Consultant's scope of work.
Yeah, so as I mentioned at the outset, so we are a boutique regulatory affairs consultancy. We provide services to the private and the public sector. We help firms get regulated, registered, licensed in many jurisdictions. In relation to the EU in particular, we are obviously very familiar with MiCA, and we help firms understand the current requirements across the EU and what it means for them to have a presence there now, and what it would mean for them in the future. We also carry out jurisdictional analysis, understanding firms' products and services to see what type of regulation will be relevant to them. We also deliver training, and I think that covers pretty much everything that we do, most of what we do at least. I hope that answers your question. I know Frederick is raising his hand again. Yes, let's let him
Hi,
speak.
thank you. Yeah, I do have quite a specific question. It's about custody of keys. As it is stated in the MiCA, this falls within the services covered by MiCA when it is being provided by a CASP. And I was wondering, how do you see custody in regards to control? So custody, like kind of in general, right? Easy by saying, okay, you hold the private key for someone else, you are able to make transaction on their behalf. So of course, this is like kind of custody. So clear, right? But what about if you hold a key where you, for example, can sign a block and then the reward for this block is being forwarded to some other wallet where you don't even have control and you can't initiate any transaction, while at the same time you can refuse to sign the block for that person you hold the key, and this would lead to not receiving the reward. would, from your understanding, fall this under custody? And if so, why?
Yeah.
I know it's a quite specific question.
It is, and it's quite an interesting one. And I know that there is quite a lot of discussion and debate around that. What does it mean to have custody if you're relying on others to be able to affect a transaction, for example? So there's definitely an element of custody there. Whether or not it's enough to fall within the definition of custody within MiCA, I think that's one that would need to be considered in detail, and that I'm hoping that there will be more clarification further down the line as well on what custody exactly means. I don't know, David, if you've got anything else to add.
Did you mention there, Frederick, that the firm providing the custody would be receiving payment for it? Are they profiting from this service, or is it?
Well, of course, I mean, giving the key to someone else, let's say an entity, to provide these services on their behalf, right, would enable them to, sign these blocks, and of course, they would get some money for that service being provided. At the same time, they kind of, could refuse to execute the signing as agreed in the contract. Nevertheless, and then probably wouldn't be entitled for any kind of remuneration anymore. Yes, they would receive money for their service and have the financial incentive to, of course, act accordingly. And if they don't, then you probably don't get any money for it. But what they can do, or the scope on what is possible by this cryptographic key they are holding in custody, is only to kind of harm, let's say, the principal in a way that they refuse to sign a block. But they don't have control of any kind of tokens. They can only generate more for the principal by signing the blocks, but can't make any transaction.
So they don't have control over the client asset, i.e. the token.
Exactly.
It's a tough one. I think it would be, the onus would be certainly be on the company to prove that it's not custody, at least under the definition of MiCA. I think it's a tough one. I'd hesitate to give a solid opinion on it, but it could go either way, I think. Yeah. Sorry, I can't be more specific on that one.
No, not at all. I would be surprised if you would. And this just shows how good arguments are being possible to be made on both sides, right? And how much needed clarity in this kind of understanding of custody is also needed, right? And it will be quite interesting because from my perspective, I couldn't find anything, even guidance in regard to custody that is going to be provided in the future. Did you find anything in regards to clarifying the definition of custody in this regard somewhere from someone?
There's a measure that will potentially be implemented to make changes to definition or clarify definitions. But there's nothing specific around that yet, and what that will mean. But I think, again, custody, it is generating a lot of discussion, and obviously ultimately having control of a private key in itself could constitute custody, and in some cases is considered to be custody. In this case, because there is a chain of events and it's not completely reliant on one entity or individual, it becomes a bit more complicated. So as you point out, I think there are arguments for and against, and you can, and as David said, the onus at the end of the day would be on the entity to prove that they are not a custodian for the purposes of MiCA.
Thank you.
Thank you, Frederick. Any other questions from anyone? We've got still have a few people on the call. No? Okay. I think we can wrap it up there then. Thank you again for those of you that are still here for attending, and we hope to see you in the next webinar. Thank you.